seated. We'll hear argument in 22-168, Bay Limited versus the Corpus Christi Catholic Diocese.
May it please the court, Ms. Voss will present argument for petitioner. Petitioner has reserved 5 minutes for rebuttal.
May it please the court. There are 4 issues today before the court in this appeal. The first one is the most important because if the court disagrees with our position, then it need not reach any of the other issues. So I'm going to spend the majority of my time talking about the one satisfaction rule. The Fourth Court of Appeals erroneously applied the one satisfaction rule in this case by focusing on an agreed judgment rather than the terms of a forbearance agreement relating to a divisible injury committed by another party in a separate lawsuit. In this case, the application of the one satisfaction rule wiped out the entire judgment for unjust enrichment. I want to first clarify something in the briefing. Bay has never argued that this was not a settlement agreement. However, it is a particular type of settlement agreement, and the court should look at the terms and the payments thereunder to determine whether or not the satisfaction rule should apply. First, in the agreement, there is no promise to pay by Michael Mendieta $1.9 million. There is an agreed judgment for $1.9 million.
So I just want to be clear that you agree with the cases that say that those are actually not 2 different things, but one contract because the one incorporates the other.
I disagree with that. I think that, yes, you have to look at both documents if they're executed together. However, there is no promise by Michael Mendieta to pay $1.9 million. If you look, the mutual covenants in the forbearance agreement only include a $750 per month payment, which is expressly allocated to a $175,000 constitutional lien against Mr. Mendieta's homestead. In exchange for those $750 a month payments, Bay has agreed to forbear foreclosure on the constitutional lien. And so if say, Mr. Mendieta stopped paying that $750 a month, then foreclosure on the remainder of that amount would be allowed and the rest of the judgment could be collected, but there would be no breach of contract action that could be brought to force Mr. Mendieta to pay $1.9 million because there is no promise to make that payment. And so
there's a judgment.
Oh, sorry.
There's an agreed judgment, right? And so the question is, why conceptually there doesn't seem to be a whole lot of space between a settlement and an agreed judgment. Often they take place simultaneously. Why would we treat them so differently?
Well, I mean, in almost every settlement where there's been litigation that's filed, there's going to be some sort of a judgment that comes along with it. But what the court's precedent has said is you have to look at what was the settlement amount. That's the first step in the Skyview analysis, is that the party that wants to claim the credit has to prove a settlement amount and that it's covering the same injury that's involved in the present lawsuit against that defendant. And that's where the 13th Court of Appeals in the Shoemate case made the correct determination and said this is not a $1.9 million settlement agreement. It is a $1.9 million agreed judgment because the parties agreed to discontinue the litigation between themselves. Mr. Mendieta chose not to fight that anymore and agreed to that judgment. However,
the settlement agreement incorporates the injury in this lawsuit as well, right? Paragraph 8 specifically refers to this lease and the improvements of real property. So it's not divorced from this lawsuit.
So that you're referring to the judgment, not the actual settlement.
All right, the judgment.
The judgment.
The agreed judgment incorporates the injury associated with this suit. And as a result of the agreed judgment and settlement agreement, each side non-suited their claims in this case. Is that right?
The parties non-suited their claims in this case.
Right.
In recognition that, that proceeding to another judgment would be barred by the rules of res judicata. The agreed judgment was in the Nueces County, separate litigation, and both parties just discontinued their litigation against each other in the Jim Wells County that is on appeal today. However, what you can't do is disregard the fact that all of the payments were actually allocated to that constitutional lien on the homestead, which is entirely separate and has nothing to do with the diocese.
But
now,
if Mr. Mendieta won the lottery or had some other non-exempt assets in the rest of his working career, he would be obligated to pay that judgment.
we could not
execute.
we could not actually execute it on it if he was making $750 payments towards the constitutional lien. So, if he chose to pay it, however, then if the diocese had already not satisfied their separate injury, then the diocese would be able to have a credit for that through the regular judgment collection processes. The Fourth Court of Appeals looked at this as the $1 million in the judgment being the settlement amount. But going to the second step, well, first, the diocese did not prove the first step of the Skyview construct, which is that there was a settlement agreement where an agreement was made to pay $1.9 million. They didn't even get
What
that,
do you
get to
contend is the amount that the settlement agreement, sort of divorcing it from the agreed judgment, what do you contend is the amount that the agreement says is the settlement amount? In other words, when do you think this agreement will be satisfied? Because I'm having trouble reconciling your position with the idea that the text contemplates the payments will continue even beyond the time that the $175,000 obligation is satisfied.
So what the language actually says is that if there are other payments,
Right.
then those would be credited to the rest of the judgment. It doesn't actually obligate Mr. Mendieta to make any of those payments. It says that he's allowed to. He's not prohibited from it, but it doesn't say anything about requiring him to actually make those continuing payments.
But isn't he legally obligated to either make those payments or to pay the judgment if he doesn't?
There is a judgment, but if we can't enforce it, then there's no legal obligation under the settlement agreement.
Look, I don't know that there wouldn't be an obligation. It's just a question of how do you enforce it.
How do we enforce it? Right. And this was, an exchange that was made in recognition of the fact that Mr. Mendieta had no money. He is paying $750 a month towards this judgment, and if he makes those payments for the rest of his life, he will never ever pay off the constitutional lien. Because with the prejudgment interest and the accruing post-judgment compounding interest at 5%, he's not even paying the interest on the judgment every year. He's only paying $9,000 per year when the interest on the judgment is in excess of $11,000 per year. So at this rate, he will never pay off that constitutional lien, which puts us into the construct of the cases where you can get two judgments in two separate cases for the same injury, and the one satisfaction rule does not bar the second judgment as long as the first judgment remains unsatisfied. And that is supported by a long history of cases going back hundreds of years.
But this judgment is being satisfied right now.
Not the part that relates to the diocese. So there are 23 different injuries Mr. Mendieta caused that are listed in the judgment. Only one of those overlaps with this case. That part of the judgment is not being satisfied and never will. So assuming that the diocese did meet its first step under Skyview, then the burden would have shifted to us to prove that there will be no double recovery because of the way the allocation of the payments were made. And unlike Skyview, we did meet that burden by pointing to the actual terms of the forbearance agreement, as well as the payments that had been made thereunder. If the court doesn't have any other questions on the one satisfaction rule, I'll proceed to the remaining arguments.
Let me just ask, I want to be clear. The Court of Appeal, here's what the Court of Appeals said, and I want to just get your clear response to this. If the diocese were to satisfy its judgment from the Jim Wells County trial, the judgment against Mendieta and Nueces County would be unaffected. Therefore, if we did not apply a settlement credit, there would remain the possibility that Bay could recover twice for the same injury, and there's no certainty that it will satisfy only one judgment. What's wrong? Help me understand why that's wrong.
So the reason that is wrong is that because judgment collection procedures in the rules of civil procedure, in the Texas Civil Practice and Remedies Code, in the Property Code on abstracted judgments, they all take into account payments made towards a judgment and the amount that is actually due on a judgment. So for example, to obtain a writ of execution on a judgment, the execution has to be for the sum actually due when it is issued and the rate of interest upon the sum due, and that's in Rule 630 of the Rules of Civil Procedure. If there were going to be a garnishment to try and attempt to collect the judgment against Mendieta after the judgment against Bay or against the diocese had been satisfied, well, then Mendieta, as the garnishee, as the judgment debtor, would be able to file a motion to dissolve the writ or to modify the writ to prove that payments had been made towards that injury and reduce the amount of the writ. An abstractive judgment, when you file an abstractive judgment, it also requires you to include the amount for which the judgment was rendered and the balance that is due. That's in Property Code 52.003. As early as 1863, this court said that the clerk has to give credit for on executions for payments that have been made towards a judgment, and that's from the Yale versus Heard case. And also, if you take a step back and go to the restatement second of judgments, section 50, it also recognizes that any consideration received by a judgment creditor in payment of the judgment debtor's obligation discharges to the extent of the amount of value received the liability of the judgment creditor of all other persons liable for the loss. So it is absolutely not correct that if a judgment was rendered against the diocese and satisfied, that Mr. Mendieta would have no available remedy. He would be able to defend against any kind of enforcement of that amount against him as part of the judgment collection process.
With the diocese?
I'm sorry?
Would the diocese have any remedy?
The diocese actually has a remedy. They have a contractual right of indemnity against Mr. Mendieta that they could pursue, assuming that he has any assets that can satisfy them for that. But if we were to ever somehow collect over and above the $175,000 plus interest on the constitutional lien, then yes, I do believe that the diocese would be able to raise a credit in that regard. If they had not already satisfied their judgment. But that's a risk that we have in every case, that one party's going to pay more than their fair share. They then have to seek indemnity and or contribution through the contribution schemes, and that is something that our collection processes already deal with.
Be sure you have a chance to address the jury instruction issue on the unjust enrichment claim. And you mentioned in your brief that we say in Wagner versus Brown, it has to be Wagner and Brown versus Shepard. It has to be a person who, in good faith, makes improvements upon property owned by another. But the jury charge doesn't mention good faith. And then in Heldenfels, we said fraud, duress, or the taking of an undue advantage, and it also doesn't mention an undue advantage. So why isn't it wrong for those reasons?
Well, Your Honor, there are numerous cases that have come since Heldenfels that recognize the passive receipt theory of
Court of Appeals cases, right?
Court of Appeals cases. That's correct.
What does the restatement say about that?
You know, I'm not recalling off the top of my head, but I can have that answer for you. And
Just wondering what other states are doing on that.
Yes, no, I don't have that answer off the top of my head, but I don't think that the passive receipts doctrine is inconsistent with Heldenfeld's, and some courts have said that it's taking an undue advantage when you passively receive something that it is unconscionable for you to retain. And there is a case that we have cited in our brief called RDG Limited Partnership versus Gexa Corp. Out of Houston. The 14th court in 2005, and the court said we can reconcile this passive receipts doctrine with the taking of the undue advantage language in Heldenfeld's, and we do not think that the court in Heldenfeld's intended to overrule that line of cases.
What about good faith?
I'm sorry?
Is good faith not required either?
I don't believe that the diocese has argued that good faith should have been in the jury charge. They only argued that it should have included undue the fraud, duress, and undue advantage.
Any other questions? Thank you, Ms. Voss. We'll hear from the respondent.
May it please the court, Mr. Houston will present argument for the respondent.
May it please the court, as the court, I guess, already acknowledges, we are ships passing in the night with whether or not we actually have a settlement agreement. It's our absolute position that there was a $1.9 million settlement agreement, and we know that because we have to construe all of these instruments together. So we have the settlement agreement, we call it, which is the thing that says agreement at the top. We have an agreed judgment, and we have these non-suits with prejudice. And I don't know how on earth that it could be construed as anything other than a settlement for $1.9 million. The agreement incorporates, by reference, the agreed final judgment. In the agreement, it says Mendieta is to pay Bay $750 per month towards satisfaction of the final judgment, and not just the $110,000 or $175,000. It recites that Mendieta and Bay each desire to non-suit their claims against the other in the Jim Wells County suit, and then Mendieta is releasing his claims against Bay in any way to the that relate in any way to the claims in the lawsuit in Nueces County or the final judgment, which we know is one of the 23 enumerated injuries, which is included. I guess you could really call this thing a global settlement agreement, because they were settling sort of 23 grievances with Mr. Mendieta, and then the agreement says that it's binding on Mendieta's heirs. And then we have the $1.9 million judgment, and then we got it's listed out having to do with the ranch in Jim Wells County. I just don't see how you can have it any other way. And if we were going to have a $175,000 forbearance agreement, why on earth did we go to the trouble to include 23 of these other things? So it's just our position, which I think that is the fundamental issue, and that is the conflict between the Fourth Court of Appeals and the 13th Court of Appeals. Was there actually even a settlement? The second issue is yes, so is there a settlement? Isn't there a settlement? And you kind of got to put it in two buckets. And so there is the bucket of the issue where the one satisfaction rule is applied, where we have a settlement agreement, and that's Skyview, that's all of those cases. And we're not really concerned about satisfaction of a judgment. We're concerned about, does the non-settling defendant have evidence of the amount of the settlement? We're not concerned about was it paid, not paid, or whatever. Now, there is the second bucket of cases that talk about
Counsel, if the agreement says, you agree that you owe me X, but you only have to pay me Y, is that a settlement for X or Y?
Well, I guess but you only have to pay me Y, then I guess it would be the Y, because that's what that's the bargain for exchange.
So why isn't the combination of this judgment and this other agreement effectively, you owe me X, but you only have to pay me Y?
Well, it's over time. So it's over time. And so so Bay voluntarily agreed to accept periodic payments. And so I, as the non-settling defendant under all the precedent, can't be punished for events over which I have no control. And so if Bay was happy to accept $1.9 million judgment at $750 a month, then that's on Bay, because it's not on me, because at the end of the day, it's not really fair for the non-settling defendant. Yeah, I didn't make that deal, and if they thought that you didn't have any money, why on earth did you do it? And there is some discussion in the briefing about we want to encourage settlements, but so that, yes, I believe Texas law says, yeah, we want to encourage an amicable resolution, but we also enforce agreements as they are written.
If we follow you that there is a settlement agreement and that you've put in evidence as to the amount of the settlement, but that can be then explained, rebutted, a number arrived at from the other side's production of information about allocation or other reasons why the one satisfaction rule should not apply. Did they meet their burden in this case showing why the one satisfaction rule should not apply?
No, and they don't, and that's kind of our big third, I guess, disagreement is that under my reading of all the cases, the burden is on the non-settling defendant just to put in the amount, and then the settling plaintiff, who's in the best position to explain, has to then allocate among the settlement amount. But the evidence here, that was an affidavit that was filed in opposition to our request for the one satisfaction rule, talking about, well, these are the payments that have been made. But I think that's the wrong inquiry, because they could have stepped through all those 23 entries and said, number one's worth $5,000, number two's worth this. And in fact, they did that because they sued and got a judgment for over $500,000 in the Jim Wells County case. They sued Mr. Shoemate, which is the subject of the other case, sued and got a judgment. So if they were able to put a value, so like take the $1.9 million and allocate it among the 23 entries, that's what I believe was their burden under Skyview, and that they've taken this second path to try and explain, no, it's these settlements because they're trying to pull it into that second bucket where we're obsessed with or we're focused on, was there a satisfaction of the judgment? But that's not ever the calculus, because as near as I can read from none of the cases going back even to the 1990s, was the non-settling defendant ever concerned about having to put on evidence whether or not the parties had complied with the contractual obligations.
What if the non-settling defendant adduced evidence that the settling defendant had filed for bankruptcy?
Well, I don't know that the burden would ever fall on us. I don't see that within the.
No, I'm saying this. So in this case, Bay would put on evidence that the co-defendant that they settled with had filed for bankruptcy, leaving the judgment unsatisfied.
Well, I guess it then begs the question is when.
Would that overcome the presumption that the one satisfaction rule applies?
I don't see how it would overcome the presumption, but at least based upon the court's precedents in this regard, it's a really minimal burden on the non-settling defendant just to put in the amount, and we're not concerned about the other stuff, because presumably the person who, the settling plaintiff, is in the best position to know if they should settle and for how much and through which means. And so here there was an admission that, well, we knew we didn't have any money in the first place, but why did you take a $1.9 million judgment? That's what's unsettling. And, we do have the one case, there's the one case out of the Southern District that involves really the only analog that I was able to find talking about where, well, the non-settling, the plaintiff had agreed to accept periodic payments, and that should be enough. And, I think that reasoning, I think, bears out, and it acknowledges the two bucket. It acknowledges that there are those cases where we're talking about, I got a default judgment against one of the defendants, they couldn't pay, then I got another judgment. But here, I guess it's sort of like it's a semantics issue, I guess, is where we are, because, there's a focus on the judgment. And so if you read sort of like some of the briefing, is that the Fourth Court of Appeals was concerned with the taking of a judgment and not satisfaction of the judgment, which I don't think that is actually the.
Well, what about this scenario? Let's say they did what you suggested they should have done. They went through each of these injuries described in the final judgment, and for this particular one, said, well, we allocate $100,000 of the 1.9 to this injury, would that be sufficient to carry their burden and you would have a $100,000 settlement credit? Or do you think that you would then sort of look behind the allocation and test its veracity somehow?
Well, I think you could test the veracity of it. I mean, I think
Wouldn't it
that,
just be enough if the face of the
well, I think then
document allocated a
right, I think then
particular
the
figure?
court, I'm sorry, I didn't talk over you.
I'm saying, don't fight the hypothetical, just take what I'm saying, which is that the agreement says it's $100,000, and it says that in its text. Is that sufficient? Does that end the inquiry?
Well, yes, because I think that it says what it says, and I think that's what was said in Ellinger, that you look at and there is some question in the cases whether or not if the settlement itself discusses, it makes an allocation, that appears to be fine, and I guess you could attempt to cross-examine people or whatever. But if it doesn't make an allocation, that's where, in Ellinger, it didn't, and so then the court said that they could, on remand, you could go back and introduce extrinsic evidence to explain an allocation. But our position here is they completely didn't do it at all. So there would be no do-over because they could have allocated. And so I guess the question is whether or not they did or didn't, they just didn't. And so it really shouldn't factor in the court's analysis.
If Mendieta were to pass away and it were revealed that he had a bunch of property somewhere, could they get at that up to 1.9 million, or does this agreement about the 750 per month, would it prevent them from getting at that?
You know, frankly, I've not really studied that issue. Presumably, they accepted the 750. I don't, presumably get into another settlement agreement. But it does beg a question, though, that Justice Bland raised about what if he did hit the lottery? So, and this whole discussion about, well, there's all these procedural mechanisms to protect somebody. I struggle to know how the diocese would ever know if it had been satisfied or not, because those procedures, because we're not a party to the Nueces County lawsuit, because at this point, if we were made to pay it, we would have satisfied, and so everyone believes, or at least the district clerk in Jim Wells County thinks that the judgment's been satisfied, but knowing there's this other collateral issue. So, I mean, and I think that's just a fundamental disagreement that we have, and there's really no way I can see to put this in the context of Skyview and the other things other than to accept there had to be that there was a settlement and it was for $1.9 million. The only allocation that's made in the settlement documents is $175,000 that relates to this house. So then you're left with $1.725 million. And I think the reasoning from the Fourth Court of Appeals is sound, and that because at the end of the day, I don't really need to know why you did $1.9 million, or all I get as a non-settling defendant, I can't be punished, and so if I didn't know, I wouldn't party to it. All I know now is this stuff gets popped up. And you're like, okay, well, explain. And if you don't, then I think you're sort of at your peril, because there's numerous cases saying, well, if you don't allocate, then all of the unallocated settlement then has to be applied to the judgment.
Isn't the diocese getting a windfall, though?
Well, I think that goes back to Justice Busby's question, because I don't believe that the question was submitted correctly on the unjust enrichment claim. And if you read the pleadings base pleadings meander through 8 million different theories on equitable remedies, assumption. They even recite, that the rule or the issue about fraud, duress, and taking undue advantage. But we have to remember there was a summary judgment that was granted, wiping out all of the claims. The trial judge reconsiders, then he resurrects only 2 claims, a claim for unjust enrichment, which he explicitly states, and a declaratory judgment claim. Well, then we proceed on through trial, the declaratory judgment claim is released, and then we're having a debate about, well, what does unjust enrichment mean? I think what it means, what the court said in Heldenfels, fraud, duress, and taking undue advantage, because I think it's not some sort of like a strict liability equitable remedy that if you got something without any sort of scienter or any other thing going on, that how is that fair? Because the evidence in this case completely bears out that the diocese did not know anything at what was going on. They signed a lease, Mr. Mendieta's out doing his deal, And they never knew anything. No, I certainly have any
Well,
evidence.
didn't the lease say that he was to make improvements, it's just that he was to bear the
Yeah,
cost
right.
of it?
And so if they don't know,
But I think they knew that he was gonna be making improvements, right?
well, but not at the expense of his employer.
Right.
And so I think that's
Is
the
that
issue.
what makes it undue, that they were at the expense of the employer?
Well-
Or whether they knew that or not?
Well, I mean, to borrow something from the earlier argument, in balancing the equities, I mean, they are the employer, weren't they in the
shouldn't be
best
balancing
position?
the equities,
Well, I mean, we're talking about sort of an equitable remedy realm of claims here. And so I would not agree, because I don't believe that the evidence would show that they got got something for fraud, duress, or taking an undue advantage. Because I don't really know even what that means.
So those are at least focused on the defendant, presumably, that the defendant committed fraud, duress, or the taking of an undue advantage. And then you have Wagner and Brown, which talks about good faith, and presumably that's focused on the plaintiff.
Presumably.
But y'all didn't ask for an instruction on good faith, is that?
We did not, and the way the charge conference went down, they wanted more than one question, and there were different iterations of things. There was a proposed jury charge, I believe it's in the record, there's at least, I think, 4 or 5 questions, I can't recall. And the trial judge, and so the trial judge's question, I objected, I said, look, Judge, I don't think it's submitting Heldenfels, and so we're just trying, I mean, it wasn't our question, but I wanted the record to be clear, in part because we were blurring, at least from my perspective, that the plaintiffs were blurring all of these claims just sort of to get what I want, and then the judge said, well, you have one claim, why would you get more than one question? Which is why there's only one question in the jury charge, and it's the question that I have argued, and I don't know off the top of my head if it's in this briefing, because you sort of ran out of space because we have these cross issues, but it was extensively briefed in the Court of Appeals. I believe the language that is used in the question that was actually submitted was submitting a claim for money it hadn't received. So the chart, and if you look at the language, if you track the language that appears in the question to this court's opinions, and it's escaping me now, but if you track those, that's a claim for money hadn't received and not one for unjust enrichment. And I do think they're different. And if you read the PJC comment to the question, it acknowledges that, well, some courts of appeals have said unjust enrichment isn't a standalone claim, but we think the Supreme Court has said that and did so in Heldenfels. So there is some dispute, which is why there's no actual question. It's just a comment. But our position is, look, the only claim that was resurrected by the judge was unjust enrichment. We have some indication from the Supreme Court how it's supposed to read. It doesn't read that way, so it can't support the judgment. So, and the other issue on that front, the other jury charge issue, which I believe is also a rendition point, because this was a fight throughout the trial, was what's the proper measure of damages for an unjust enrichment claim where you were claiming there were improvements to real property that somebody owns. So I think it's the Stacy case that says, well, it's the value, the increase in value of the real property as a result of the work done, not the value of your services. And I think that bears out in some other cases, and so we objected to that as well. And in fact, they took the position at trial that no, it has to be the value of our services, and actually sought and was successful in excluding any evidence of the other measure of value, of the other measure of damages. So there is no evidence of the record of what the increase in the value of the ranch was as it relates to the work that Mr. Mendieta did, obviously without our knowledge.
The jury question doesn't really seem to submit either measure. It just says, what's the reasonable value of such property or benefit? And it doesn't really seem to say, that means cost of improvements, that means enhancement of land value. It just says property or benefit. So.
Yeah, I believe the proposal we had, or I can't recall now, that I know for sure there was an objection to that, to the form of that question, that's objecting because it was it doesn't, to your point, doesn't really say anything, and it certainly doesn't speak to the issue in that Stacy case that the evidence needs to reflect the value of the increase in value, and It's in the briefing, and there's other cases that were, in fact, one of them where the plaintiff was seeking the value of his services, but there was evidence in the record of the increase in value. So ultimately the court says, okay, that's fine, you can't get that, but there was evidence of this other type of value, which is, then I say also becomes important in our case, like I said, because there was no evidence of what the increase in value was. And I think, there's just back to just one last point, I don't have much time left. I just think as the court is looking at this issue and balancing the two buckets, the settlement credit bucket and then this, multiple judgments, at the end of the day, I think that the only fair thing is that a settlement is fundamentally a different animal than a judgment, and we treat them differently for good reason, because I think it's a contractual obligation, and I think to draw a different distinction or to somehow create a new rule that we're maybe a third bucket, if you're accepting periodic payments and there becomes this third question, but I don't think the court needs to go there. I mean, these were ably advised people with counsel, and they made these agreements and should have to live with what they say. And if there's no further questions, I'll give my time.
Any other questions? Thank you, Mr. Houston. Ms. Voss, you have 5 minutes.
Thank you, Your Honor. I respectfully disagree with my dear friend, Mr. Houston's positions on the Skyview burden, primarily because if we get to the second step where the burden shifted to Bay to allocate, what the court's language actually says is that you have to show that the settlement proceeds are allocated in such a way that there will be no double recovery. So I disagree that we're not concerned about payments or what the payments were expected to be.
But you did not, there's a forbearance agreement. Is there a covenant not to execute?
Yes, there is.
On the entire judgment?
Yes, there is, as long as the payments are being made.
Right,
Now,
so that's conditioned on, it's a forbearance agreement, but execution will issue if the judgment is not satisfied according to the terms of the agreement.
no, if
The $750 stops being paid.
If he stops paying $750, then yes, we can choose to enforce. If he pays the full $175,000 plus interest, then the constitutional lien gets released, and that is the consideration that we gave in exchange for the agreement. And so, but there is nothing to obligate him to keep paying after that, except for that we can then
Except you
execute.
have a covenant not to execute, right?
We have as long as he keeps paying.
Correct,
But
but
if
then when that's finished, you can execute.
we can, and if we get to that point, and the judgment gets reinstated against the diocese and hasn't been satisfied, then they would get a credit for
You
that.
asked how would they know if it's been satisfied, if Mendieta wins the lottery and pays all this, how would they know?
So the Texas Property Code addresses that specifically in section 52.005, and it says that satisfaction can be shown by recording of the return of execution. It could also be satisfied by a release or a receipt that's recorded. And so, and also we would have to modify our abstract to keep up with the amounts if we wanted to continue to enforce and seek a writ of execution, because the clerk is only allowed to issue execution for the amount that's actually due. So it would only take looking at the property records.
What if he were to pass away and for that reason stop paying the $750?
The forbearance agreement deals with that. It says that until he either stops paying or he dies.
Right, but then would his estate still owe the judgment?
Then we would be able to execute. We would be able to execute.
Right, so, I mean,
And if he had not paid off the 175,
unless
then.
has a supernatural lifespan, he's going to pass away with most of that 1.9 million still owed, and you're saying at that point you could get it from his estate if his estate
If there's anything in the
had money.
estate.
Yeah.
If there's anything in the estate. Now, the big problem I see with this in focusing on the judgment is if we had just taken the judgment and we had never, issued or entered into this forbearance agreement, just got the judgment, there would be no question that there would be no issue with obtaining a judgment against the diocese. But Bay is being essentially punished for trying to seek at least some recovery for a smaller amount that related to a divisible injury. And by focusing on just the judgment, that ignores the whole purpose of the one satisfaction rule, which is to prevent a double recovery.
But why wouldn't we treat an agreed judgment just like a settlement for purposes of avoiding double recovery?
Well, because it may not ever be collectible.
Same with the settlement. Like both are agreements that I'm now going to owe you this money, and we're going to stop litigating. One says judgment at the top, the other says settlement. Why would we treat those so differently?
In most cases, this is going to be addressed in Chapter 33, which defines a settling party as someone who has paid or promised to pay. And so that's how this is normally addressed, is through that promise to pay, whether they've been paid or not. One satisfaction rule actually talks about, is there a double recovery? Is rendering this judgment going to allow the collection of more than one recovery? And when you're looking at an agreed judgment and a forbearance agreement and the payments that are actually made, it's clear under this case that there will actually be zero recovery for the injuries suffered out at the ranch because of the application of the erroneous application of the one satisfaction rule in this case. So we request that the court reverse the Court of Appeals judgment, order an award of attorney's fees in the amount that we requested. Thank you.
Any other questions? Thank you, Ms. Voss. The case is submitted. The court will take another brief recess. All rise.
Head to the airport.
Good to see them.